Thank you all for joining us this afternoon. My name is Daniel O'Neill. I'm the chair of the HYLA CLE committee this bar year. This is an excellent topic we put together with a fantastic panel. So I'm going to go ahead and introduce everybody and let them get things underway. Ryan Frankel is one of the finest young lawyers I've met through HYLA. Since I age out of HYLA at the end of the bar year, the future of HYLA looks bright with people like him continuing to lead in the organization. You all may best remember Ryan in HYLA circles as the co-chair of the Evening with the Judiciary Committee when we joined him in person at the Grove downtown in last October, during that brief interval between the Delta and Omicron variants when it was nice to be around other people at that time. Ryan is an associate at McGuireWood. He completed undergrad and law school at UT, where he was an editorial board member of the Review of Litigation. Recently, he was selected for inclusion in Ones to Watch in commercial litigation by the best lawyers in America. Ryan came to us with this topic idea and he formed this outstanding panel. So joining Ryan on the panel, we have Miles Indest, also an associate at McGuireWood. Miles is a Texas, Louisiana litigator. He completed undergrad at LSU and his JD and MBA at Tulane, where he was a judicial intern to Jerry Brown in the United States Bankruptcy Court for the Eastern District of Louisiana and judicial intern to Eugene Davis in the Fifth Circuit. Recently, he was selected for inclusion in Best Lawyers Ones to Watch for Commercial Litigation and Oil and Gas Law. We also have Yasser Madriz, the office managing partner for McGuireWood's Houston location. You will hear from the other speakers all of his other fine credentials. And last but not least, we have Meghaan Madriz, who will be joining us approximately 12:30. She is a partner at McGuireWood. She completed undergrad at Tulane and her JD at William & Mary. During the pandemic, she's authored numerous articles on COVID-related issues. She was selected for inclusion in Texas Super Lawyers Rising Stars for Employment and Labor for a number of years, starting back in 2013. And recently, she was named a 500 leading U.S. corporate employment lawyers by Law Dragon. She regularly gives back to the community and carries a strong pro bono docket, particularly in cases presenting opportunities to help children and families in need. So the MCLE number is going to be put in the chat later on. If y'all have questions throughout the presentation, please put them in the chat and they will be gotten to as soon as they can. So thank you all speakers for joining us on this panel. We're excited to hear about this topic. So I'll turn this over to you.
Thank you very much. And I'll go ahead and share my screen, Ryan, if you want to take it from here.
Yeah, absolutely. Well, Dan, first of all, thanks to Daniel for those kind, undeserving words. We were super excited when Daniel and Lucy told us we could present this topic. This is one we deal with very frequently in our practice, which our practice probably 75% trade secret misappropriation cases. And so being able to share this with you is certainly a joy for us, and we hope you enjoy it. But we have a little bit of an introduction. Miles, next slide. I'll let Yasser introduce himself and Meghaan, although Daniel's words already did us plenty of justice.
So, as is pretty evident, Meghaan Madriz, I am her husband. She is, I wouldn't say my better half, I would say my 95% better half, or half. She is the head of the Labor and Employment group at McGuireWood's Houston office. And I've been practicing with her for now about 13 years. Unbelievable how quickly time flies. My name is Yasser Madriz. I've been practicing over 20 years. As Ryan stated, the majority of our practice is trade secret misappropriation work. And it's kind of a hybrid practice because it implicates several practices, several disciplines. It includes labor and employment, general litigation, and sometimes intellectual property. I also have the distinction of being the office managing partner of McGuireWood.
All right, and I'm Miles. I'll add a little bit that Yasser, he's very, very humble, as you can tell, but he also has over 20 years of practice in this realm, and he is very good about teaching his team about the trade secret practice. And when I first joined as an associate, he told me, get ready for a lot of courtroom experience, a lot of trial experience, because as you'll see today, there's so many emergency hearings that take place. And Yasser him and Meghaan are well known for a in this area and teaching others and giving everyone opportunities to go do these TROs and succeed. So just briefly, I'm from Louisiana. I'm licensed in Texas and Louisiana, and I do mostly trade secret work. And I have the pleasure of working with Ryan as well. And I'll let Ryan take it away.
Yeah, I can't say enough good things about our team. Just to introduce myself briefly, I'm Ryan Frankel. I was born and raised in Houston, went to UT for undergrad and for law school. And now I am at McGuireWood's LLP, where I do commercial litigation with an emphasis in trade secret law. And to the extent any young lawyers want to know more about trade secret law, I think, it's especially for lawyers who want to young lawyers who want to get their feet wet. It's a wonderful avenue. As Miles said, there are a lot of emergency hearings, and with many jury trials kind of dying in the commercial space, temporary injunction hearings and TROs are really one of the few places you can get some face time with judges. Miles, next slide. So today's topics are really twofold. Obviously, as you can see, there are subparts, but the first one is, what are trade secrets? What is misappropriation? And why are they important? And so first, we'll define trade secrets and misappropriation. We'll go through then a couple of the normal type of lawsuits that we see in our practice. Obviously, there are plenty of other trade secret misappropriation lawsuits, but we feel these are the most common. And then we'll discuss kind of what are your remedies for trade secret misappropriation. And especially nowadays, the TRO and the TI kind of go towards the injunctive relief. But as we're dealing with right now, one of our major cases, there's a big monetary damages component. And second, we'll talk about the bulk of today's discussion, which is temporary restraining orders. So we'll discuss why would you go get a TRO, the rules for getting a TRO, and then our wonderful team of Yasser and Meghaan Madriz will talk a lot about practical considerations, and maybe if we're fortunate enough, we'll share some of their war stories. So what are trade secrets? And as Ron Burgundy would tell you, they're a pretty big deal.
And we'll talk a little bit about the statutory definition. We can always look up the statute, but I'll try not to read it just the text. I want to focus on the key points, and that's that it is a very soft standard. They call it soft IP for a reason, because it can really include a compilation of data. You may see stuff that's online, such as you may know a customer that's on a website somewhere, but you're rarely going to see your client's customer list posted online somewhere. And that is often a lot of what's at dispute in these trade secret cases is this information generally known to the public, or is it something that is kept secret and secure by your client? And that's why compilation becomes such an important tool, because each client has a very specific set of information that helps them succeed. And additionally, the standard is whether it's not generally known or not being readily ascertainable by proper means. So while there may be some times where you can get some of the information online, if it's not readily ascertainable, or you have to go in and pull all the pieces together, or maybe you share it with some third party through an NDA, it may be shared outside of your company, but you put in these reasonable safeguards and these reasonable restrictions that make it not readily ascertainable in the public domain. And then finally, you have to keep efforts to maintain reasonableness and secrecy. And that goes from the very start of the employment process to how you onboard employees, what employee handbooks they're signing, what code of conduct restrictions they have. Do you have a non-disclosure agreement with these customers? With your employees? And then do you actually enforce it? If you let employees go and never follow up on their duties, that's an issue that you need to look at. And finally, does all of this put together give the company an independent economic value? Do these safeguards, does this compilation of information, is it providing your company value? And that's why it's so important, because in many of these cases, the trade secret judgments are in the several hundred millions, because trade secrets are so important. And it's not like a patent where you have a 20-year life or certain limited protection and everything's in the public domain, and then after those years, anyone can use it. Trade secrets have a very long life sometimes, and it's really important because it can provide a lot of value to your client. And also you want to make sure when employees come over from other companies that you're shielding them from bringing over information from that customer. So that's what a trade secret is generally. The second is what, yes, go ahead, Yas.
One of the things that I'll chime in, Miles did a phenomenal job going over the definition of trade secrets. And Miles and I, one of the things that we always like to do is put it in layman terms to clients, because when the clients ask you, well, what's a trade secret, right? If you show them or read them this definition, they're going to have a puzzled look in their face, right? Because it's very technical. The way we typically like to say is a trade secret can be anything, any information, anything that is secret, not generally easily subject to reverse engineering or obvious, and it gives your client, or it gives somebody an economic advantage in competing in the industry. That's what a trade secret is in layman's terms. It can be anything. Think Coca-Cola, the recipe of Pepsi, or Apple's source code in all its devices.
Right. And so then the thing is misappropriation. And again, there's a long statutory reason, but it's really about, was it acquired by proper means or not? It doesn't necessarily have to be used. It could just be disclosed. So if one employee goes to another competitor and discloses it and say, hey, I have all this information, that could be a violation or a misappropriation if they take it and they acquire it with improper means. It doesn't necessarily have to be use. And we'll talk about that later when we get into the damages portion. Use is definitely something strong to show a jury. It definitely shows, it helps show intent, and it is often shown at trial. But just the fact that you're bringing it over to a competitor in and of itself could be misappropriation. And then another thing is, if you could have acquired it by proper means, that may not be relevant. So if you tell the jury, look, I could have went online and got all this information, the question is, well, did you? That may help in some instances, but as far as the misappropriation element, just because you could have gotten it by proper means, if that's not the way you did it, that's going to go against you at trial. Yasser, Ryan, anything to add on this line?
The one thing I would say is this is the statute in Texas, and the important thing here for us practitioners that have been doing or handling trade secret misappropriation cases before the statute was enacted is the disclosure or use, as Miles pointed out. Before, there was an incredible emphasis on not only having wrongdoer steal the trade secret, but also using it. The fact that now we believe that this statute has specifically made it clear that actual theft and potential use is enough to actually give someone a right to initiate a cause of action.
And this may be a good time for a full disclaimer that we are talking about Texas law here, mostly under TUTSA. We do not represent any other views of the firm in other states, and that is the quick little disclaimer on that. But this is our Texas understanding.
And Miles, very important, because the law can fluctuate from state to state.
And Miles, we should also add, and I'm sure Yasser can speak more to this, but one big wrinkle in determining whether there's misappropriation in a lot of cases, as I'm sure Yasser and Miles can speak to more, but one big wrinkle is when there's a spoliation, an issue of spoliation. There are some times where a departing employee gets a letter from its former employer and says, hey, you have a duty to preserve all the stuff you stole from us. And then that employee, kind of to hide the evidence, destroys it. You then have a big issue of, well, did that information make it to the competitor? What did the departing employee do with the information before he or she destroyed it, and what have you? And unfortunately, the issue of spoliation and evidence preservation is very prominent in these trade secret misappropriation cases, and it tends to get very contentious because of that.
Right. And I'll just add that that topic is something we're very familiar with, not only spoliation, but forensic evidence. We conduct that every day in these cases, but that would be a full topic for another presentation that hopefully we can provide next time as a full topic on forensic presentation and how you determine what USBs are plugged into computers, what files are opened. But that is something very important to these cases. But because of the electronic data in today's age, it really comes down to what attention to detail can you get into the weeds of these computer files and find out what was done on these computers. Even after they wipe them, they may wipe everything and there's still remnants of it. But again, that's a big topic for another day. All right, let's move on to the next slide, which is the common types of trade secret lawsuits. These are just the general format of what you see. Often it's an employer versus a former employee. Maybe if it's a small scenario where they're trying to preserve their trade secrets, business A versus business B, and then more commonly you'll see business A versus the employee and business B, and that's for various strategic reasons. But these are just the general types of form that we see in the trade secret lawsuit. When we get to remedies, we're going to talk about TROs mostly today, but we want to touch on again why it's so important. We've seen a rise of trade secret litigation. The DTSA was enacted, and after that, there's been a lot of federal increase in trade secret litigation. But even without that, people are trying to enforce their values. They're trying to enforce the money that they expend on forecasting, financing, investing in R&D. It is a very valuable field for attorneys too, because clients want to find a way to protect their information. There's leaks of information all over, from cybersecurity attacks to departing employees. And now we're in the COVID era, post-pandemic, hopefully, where there was a lot of people working remotely, and laptops, cell phones, everything was just not necessarily on the home server, the computer, the employer server. So damages, they can range from actual damages to lost profits. We see a lot of future lost profits awards. There's also something called a royalty damage, where it's as if the employer A and the employer B got together and said, hey, I'm going to license this trade secret to you. This is what you'll have to pay to license it. It's a lump sum payment. I know it's called a hypothetical negotiation of a royalty. It comes from the patent world, but that is also a damage model in this case. It's a reasonable royalty, assuming that the stealing employer had done it the right way and gotten to some licensing arrangement. It's a very flexible, fluid test because it hasn't often been done in courts yet. But as far as damage awards outside of royalties, we've seen some big ones, notably one in Virginia for $920 million, and then Waymo versus Uber. A lot of people may have kept up with that in the news. That was settled for $245 million. Of course, there's attorney fee recovery in certain instances. There's actually punitive damages up to 3 times if there's willful or intentional misappropriation. And then there's permanent injunctions, temporary injunctions to stop the use of your information moving forward. But as y'all are all here today, we're starting in reverse. We're going to start and finish this presentation with temporary restraining orders and why that's so important.
So before we move to the next slide, what I'd like to focus is the last 3 bullets. So we have Meghaan just joined us right now. Welcome, Meghaan. But if you look at the last 3 bullets, permanent injunctions, temporary restraining order, what is that? When you file a lawsuit, you have your causes of action. You have a trade secret misappropriation claim. You may have a breach of contract claim based on the employee's breach of their confidentiality obligations, their non-competes or non-solicitations, and various other potential causes of action. That's how you go after them for liability. So the injunction component is how you protect your client from immediate harm relating to somebody, a wrongdoer possessing highly confidential trade secret information. Again, think Coca-Cola, and Pepsi gets Coca-Cola's recipe. What does Coca-Cola do? I mean, does a typical lawsuit has a lifespan of 16 months? Does Coca-Cola sit around and file a lawsuit and wait until they get an actual trial, which in today's day and age with the pandemic can be far more than 16 months, right? No, you go and you pursue an injunction. Injunction asks the court, it's an extraordinary relief where you ask the court to grant immediate extraordinary protection so that maintains the status quo, that prevents a wrongdoer from benefiting and deriving value from their misappropriation of somebody else's confidential intellectual property. And the first step to that is a temporary restraining order. Next slide, please.
And just before we go on, if you're a Pepsi drinker out there, Yasser does apologize. He's not attacking you personally. He loves Coke.
That's right. So the focus, as we said, is a temporary restraining order. Next slide. So what is a temporary restraining order? It is extraordinary relief sought in emergency circumstances. You ask the court, basically, in conjunction with filing a lawsuit, you ask the court to enjoin somebody from doing certain things or forcing them to do certain things. Like, for instance, forcing the parties to turn over confidential external drives possessing significant amounts of their former employer's confidential information, or if an employee leaves to go to a competitor and takes their former employer issued computer, a temporary restraining order can ask the court to actually compel that production. So a temporary restraining order lasts for 14 days. It can be extended by another 14 days by the discretion of the court. It's very important. The court only has the ability to grant a total of 28 days of temporary restraining order protection on its own. In order to get a longer period of protection under a temporary restraining order, it can only be done by either A, getting the other parties to agree, or B, having to go and get a separate temporary restraining order. The purpose of the temporary restraining order, like I mentioned, is to protect the status quo. Oftentimes, it's very important to pursue a temporary restraining order, even if it doesn't get denied. Even if it ultimately gets denied, is very important because the owner of a trade secret has a duty to zealously protect it and safeguard it against improper disclosure and use. So if you're not doing enough as the owner of a trade secret to actually protect it and prevent disclosure, and in the event that a disclosure occurs, to try to remedy it, it could potentially undermine your ability to preserve those trade secret protections afforded under the law.
I wanted to put y'all on the spot real quick, Yasser and Meghaan. If y'all at this time maybe could give some examples of what you may request in a TRO of, whether even if it's for a restricted covenant type of case. Meghaan, you have a lot of work in the labor employment realm. So when it comes to actual what we talk about preserving the status quo, what are some specific types of relief that help preserve the status quo?
Sure. So, let's talk about when it comes to trade secrets. And this is something that I think practitioners will debate. But at a threshold level, you're going to ask that the defendants not use or disclose your confidential information in your trade secrets. Where I think practitioners can diverge is how detailed that definition of confidential information or trade secret needs to be in the TRO. Oftentimes you're moving quickly, and so you might have a very high level definition, or you're borrowing a definition that's taken from an employment agreement or a confidentiality provision in some type of an agreement that the employee or the other party has signed. And so you're just copying that very overbroad or very broad definition of confidential information. And that's generally put in there as they can't, use or disclose that information. But certainly if you know that they've taken certain files, that they've taken certain documents because your forensics have shown it, they emailed it to themselves, I think it's smart to be specific. The more specific you can be in your TRO, the better you are in terms of potentially getting, if you have to file a motion for contempt to show that they violated it. I like to be as specific as possible. And certainly, we're not, the purpose of today is not to talk about a TI, but in a TI, you're going to want to be as specific as possible, because otherwise you risk the temporary injunction being overturned from an appellate perspective. So that's something, in the trade secret realm, that's something that you would have in your TRO, as Yasser mentioned, putting in there that they have to return anything that they, if they have hard copy documents that they may have to have them return that. You want to be careful to not have, conflicting provisions in your TRO, where on the one hand, you're saying, okay, well, you have to return everything. But on the other hand, you want to make sure that they're preserving evidence, right? So you don't want them to say, oh, well, you told me I had to return everything. So I went into my computer and I started pulling all the files that I think I took. And now all the metadata has been tampered with. And so you want to make sure, generally what I like to do is I like to say, if you have hard copy files, return them. Anything else from electronic perspective, it needs to, we need to preserve it, because it's going to need to be imaged. We're going to need to make sure we preserve that evidence as of the time of filing, in case, so we're, like I said, we're not overwriting potential evidence that we have showing that they were using that information.
All right, that's very, very helpful. Ryan, I think we can go into now some of the specific rules.
Right. Yeah.
And sorry, one more thing. I was going to say one more thing to add, and this is all very judge specific. So when you're going and seeking your TRO, oftentimes I generally, as a general matter, will put in there my request for expedited discovery. What is the discovery that I want before the temporary injunction hearing? How many, depositions? What interrogatories, requests for production? I like to put it in there. Now, some ancillary judges, generally what they do is, at least in Harris County, most of the presiding judges have different rules and procedures. It's not generally on there. It's not published. I think it's something that the judges have just access to, that will say, for a case for them at the TRO stage, they want to be the ones to decide expedited discovery, so it can't be included in the TRO. So generally, I include it in my request for a TRO, and if the ancillary judge will typically check to see who your assigned judge is, what their rules are, and if they don't speak on it, they'll grant you the expedited discovery. If not, if the judge that's been assigned to your case says that they want to make that decision, then you'll have to file a separate motion for expedited discovery with the judge who is presiding over your case.
And again, what I would like to focus everybody's attention on is the whole purpose of a TRO and an injunction is protection. Protection from somebody that's been aggrieved and is going to suffer irreparable and imminent harm, right? So what do? You don't just file a lawsuit, you seek extraordinary protection. The purpose of it is to protect, to have that protection from the very beginning of the lawsuit all the way through the end. So the temporary restraining order protects you up until you have an ability to have the temporary injunction. If the temporary injunction is awarded, it'll be valid until you have a trial on the merits. And then if you win in the trial on the merits, you'll have a permanent injunction. So it provides you the whole gambit of protection from the beginning of the filing and until the end, if you're successful in actually convincing the court to grant all three. So one of the things I also want to stress is the powerful nature of a temporary restraining order. The temporary restraining order is one of the few items that is valid when it is issued, if done correctly, and it doesn't have to be, service of process does not have to be effectuated on the target of the temporary restraining order. All you have to do is give them notice. That's powerful because under the Constitution, every party has a right to have service of process effectuated upon them in order for them to have to respond to the lawsuit. But in the context of a temporary restraining order, all you have to do is give them notice. So keep that in mind. Again, the overarching goal is giving an aggrieved person protection and maintaining the status quo.
All right, and Ryan's going to go into more detail on that whole ex parte process as well and what rules to follow. Right.
Yeah, and obviously the nuggets we've given so far are I guess, at least in my opinion, are invaluable. But at the very least, to even get into some of these practical considerations, it's very simple. You need to know the rules and you need to follow them. I mean, I guess some judges can be a little bit more lenient, but most aren't. So if you're not following the correct rules in seeking a temporary restraining order, you're not getting it. So next slide, Miles. So in an application for a TRO, there are a bunch of different requirements. Among them are, of course, standard requirements for any lawsuit. To start with, you have to plead a valid cause of action. So I think, at least going back to some of my bar prep material, for example, I think negligent infliction of emotional distress is now a valid cause of action in Texas. So if you pled that and sought a TRO based on that, you wouldn't be able to get a TRO. Why? Because it's not a cause of action that exists in Texas. Just like any lawsuit, of course, you need to plead a valid cause of action, or you're not getting this type of injunctive relief. Second is you have to demonstrate a probable right to relief that you seek on the final hearing. Generally speaking, especially if this is an ex parte, TRO, which I'll get into soon, it sounds like a pretty high burden. What it sounds like is it's like, oh wow, I already have to prove my case and I just filed it. It sounds like a high burden, but again, especially when it's ex parte, it's really not a high burden. I think the judges are a little bit more lenient about that. And then the third is perhaps the most interesting and complex prong, which is that you'll suffer probable injury unless the court grants TRO. So probable injury consists of 3 prongs, whether harm is imminent. And so with harm being imminent, it's exactly how it sounds, right? In that if you can't show that but for the TRO, you will be harmed almost immediately, you're not going to get a TRO. If you would only be able to show, well, if you give me this TRO or don't give me this TRO, I won't be harmed tomorrow, but instead I'll be harmed in a few years, then harm isn't imminent. The second prong is injury would be irreparable. This kind of goes with the third prong and makes it a little bit more complex because, at least from what I've seen, oftentimes a party seeking a TRO in their original petition isn't just seeking injunctive relief, they're also seeking damages. And so oftentimes the opposing counsel will argue, well, if you say you have no adequate remedy at law, how are you also seeking damages? Usually the argument, the corollary argument is, well, I am seeking damages, but those damages are incredibly hard to calculate. So that always becomes a fight when you're seeking a TRO, but also, or a TI, but also damages. Being able to say, well, yes, I'm seeking damages, but that doesn't mean I have another adequate remedy at law. Included in TRO is a request for a temporary injunction. As Yasser and Meghaan have already described, TROs are very temporary. They only last for 14 days initially, and then a judge can, upon motion, grant another 14 days. Of course, parties can also agree to extend them longer. Meghaan and I, when about 6 months ago, had a case where Meghaan, I think the TRO was extended beyond 28 days by agreement of the parties just because of scheduling conflicts. But in any case, obviously, it does not last as long as a temporary injunction, which, as Yasser described, could last years because it takes, especially nowadays with the backup of cases due to COVID, it could take years to get to trial.
Let me ask a quick question. Yasser, what's the longest you've seen a case go, wait till trial and have this injunction sitting in? I mean, we're talking about like 1 year, 2 years. What's the longest you've seen an injunction in place until trial, protecting the client?
I think that we're aware of one right now that's probably
Yep.
5 years. But typically the way it works is it's all about expedited resolution, right? And why? Because of the implication of the incredible value that's at stake, right? The incredible, incalculable, unascertainable losses that the aggrieved party can sustain, right? Because of that, they want to always either they want to have some sort of a protection throughout the interim of the trial, irrespective of however long it takes. Could be it could be a year, it could be years. Both parties are always going to want to get to trial as soon as possible, even if there is an injunction. If you're the plaintiff, even if there's an injunction in place, you want to get to trial, get this resolved once and for all. If you're the defendant, conversely, and there's an injunction issued, you absolutely want to get to trial as soon as possible because you don't want to be restricted in any way, shape, or form, right? So sometimes what you'll notice is when you get to the temporary injunction stage, how the court rules often plays a big part on how the case will proceed. If an injunction is issued, you'll see the defendant wanting to get the case resolved as soon as possible. On the other hand, if an injunction isn't issued, you will see a plaintiff want to go ahead and pursue an expedited trial date so that they can get their day in court and have the adequate protection once they present their case on the merits.
And Yasser, can you also talk really quickly about how a TCPA motion, like this case we're all thinking of right now, how a TCPA motion might affect, especially if you get an agreed injunction before the TCPA motion is filed, how that might affect how prolonged the TI is?
Happy to do it, but I'm going to defer to my better 85% because that's one of her specialties.
Yeah, so those actually, Ryan, that's a great question because I know that was that issue in one of the cases that y'all are referring to, but that is no longer an issue anymore in the trade secret context when the statute was amended. So you can no longer, you're referring to Texas, an anti-SLAPP?
Yes.
Right.
Yeah, so that was the defense bar creatively used that to try to essentially get early dismissals of trade secret, non-compete, unfair competition claims, and the appellate courts were very warming up to them, and in some cases did get dismissed, and even if not, it was just used as a defensive mechanism to try to get the parties to an early settlement. Our state legislature saw that and saw that the statute was being used in a way that it wasn't supposed to be, at least not the intent of it, and the statute was amended, I believe, in 2020. Might have been 2019, 2020, but you can no longer file one for just a trade secret case.
But to Ryan's point, so for cases post amendment, it's no longer an issue. For cases that were initiated before the amendment, then that may be an issue.
Yeah, and there are other cases certainly that could have a trade secret component where it would still, it would, like, for example, defamation, where it could still, an anti-SLAPP action could still be filed.
Right.
All right, Ryan, last point I think here is about a bond requirement, which we'll talk in more detail next or in later. So we can go to the next slide if you think, Ryan.
Well, I think there's 2 more points, Miles, and I'll make them quick, I promise.
You're right.
So yeah, the TRO has to be verified with affidavits or sworn to. And then one thing Meghaan actually brought to my attention this morning, which we thought was a cool nugget, which is when you're seeking a TRO or TI, the proper venue has to be where at least one of the parties against whom the applicant is seeking the injunction resides. So if I'm suing Yasser, Meghaan, and Miles, God forbid, but I am only seeking an injunction against all 3, I can choose, if Yasser lives in Harris County, Meghaan lives in Tarrant County, and Miles lives in Travis County, I can choose any of those 3 counties. Next slide, Miles. And so as we've kind of already previewed, the court often and most of the time does conduct a hearing on the temporary restraining order. But unlike a temporary injunction hearing, it's not an evidentiary hearing. So you don't put on live witness testimony. I don't think generally there is a court reporter. They're much more informal than TI hearings. A couple of months ago, Meghaan and I had a TRO hearing by phone. I was in my apartment, she was in her house, and it was very quick and very informal. But in that case, actually, it was an ex parte hearing. But that's because we did give proper notice to the other side and they didn't show up. Oftentimes, however, parties will both be present, but the court has discretion. Next slide, Miles.
And I'll just add too, Ryan, I've been in courts not in Harris County, but in some of the surrounding counties of Harris County, and they'll just take the papers back and there will be no oral argument. The judge just looks at the what's on file in terms of the petition and the TRO, and will sometimes mark it up and sign it or deny it that way. So I've had that happen before where I haven't even had a chance to give any oral argument.
Right. And to some of our earlier points, TROs can be ex parte. What does that mean, Miles? Next slide. That means, as Meghaan is kind of alluding to, you can get a temporary restraining order without a hearing and without both sides present. Most of the time, you have to give notice. So an example of where you wouldn't give notice would first of all, you have to, if you don't give notice, you have to put that in your application. But an example of where you wouldn't give notice would be a situation where basically giving notice to the other party would create the irreparable harm that you're seeking to enjoin. So if Yasser, for example, were embezzling money, again, God forbid, and I wanted a injunction to prevent him from doing so, but giving notice of giving him notice of the temporary restraining order would tip him off and make him cover his tracks, then it may be worth seeking an application where you didn't have to give notice. But as I said, you do have to explain that in your application. You could probably make the same argument for trade secret cases too, right? Because once they get notice of the TRO, the party performing the misconduct may then try to, cover their tracks. So that's certainly a practical consideration.
And in that context, maybe you don't call the court, you call up Meghaan and she'll handle it pretty quickly for us if Yasser was doing something wrong.
Exactly. And as Meghaan astutely pointed out, local rules, and not just local rules, different detail different requirements, but different judges have different proclivities. That's obviously the same with motion practice, among other things. But for TROs, we've had judges where we've thought certain non-compete agreements were enforceable under the law, but some judges just, at least from at the temporary restraining order stage, just do not want to restrain someone from competing. And they may then go and punt that to the next judge for the TI hearing. But different judges just have different preferences. Next slide, Miles.
All right, now we're going to talk about the actual order. We know how to appear to the court, what requirements, or what is the process, but what does the actual order, what are you trying to obtain? We talked about some of the relief that should be in the order, but it has to be very clear. It has to be very specific. And if the TRO is not signed by the judge, it's not enforceable by contempt. And that is going to be important for both a TRO and a TI. Having enforceable for whether it's the 14 days of the TRO or the longer time for a TI really helps you, because it keeps the status quo in check. And sometimes you may need to file a motion for contempt if evidence is being destroyed or tampered with, or let's say you have a non-solicitation provision where your employee has gone to a competitor and the TRO says you can no longer contact customer A or customer B for these 2 weeks. And yet you have a private investigator or someone telling you this person's going to have lunch with them, or in discovery, you obtain GPS data from their cell phone or Uber receipts showing that they were going to that client A and B's headquarters. Those may all go to show contempt at some point, which could help again throughout your case. So it is very important to have this order signed, have it in the proper form, have it enforceable, because it is going to be carried out throughout the case. The TRO for the limited time, and then the TI for the rest of the case. We talked about some of the other terms, and it has to identify the person or entity. You want to be very specific about who it's enforced against. Sometimes there's an entity with multiple affiliates. If you haven't named them as a defendant, you really want to make sure you include language such as this defendant or any owners, affiliates, agents. Again, the less specific you are, the more risks, but you do want to make sure you cover the employees of that company or the affiliates and other entities. You have to go ahead.
And I'll just add to that, Miles. So Rule 680 actually says who specifically who an injunction or a TRO or a TI can bind in addition to the named defendants in the case. So as a general rule, I just like to track that language. So you're not, subject to any type of appellate record. Basically it's anyone who, it's like Miles said, kind of an agent's employees who have actual notice of the TRO or the TI. But as just from a drafting perspective, I would try to track the language of 680.
And Miles, also to be clear, just to all, everyone listening, and Meghaan is the master at the drafting of the proposed order. But usually, again, different judges like marking up different things. Some judges just take a look and say, oh, this is great, whatever. Other judges are much more inclined to redline your proposed order. But the proposed orders, as we're kind of saying, have to conform with the Texas Rules of Civil Procedure. And again, Meghaan is, in the cases we've been on together, has been the master at that. So she can certainly provide a lot more input than I can.
And the attention to detail is important because while you may get it signed because it's on a rushed ex parte basis, as soon as the other side shows up, they may call it out and get it overturned. So
Right.
just remember that you may, the judge may be quick to sign it or rush it or, you know, whatever it may be. But that's, if it's because of an ex parte, you want to do the due diligence up front, because I don't think the judge will be very happy if you encourage them to sign something without doing your homework, and then it has to be clarified by the other side when they finally do show up.
Absolutely.
And another just point to add about this is that generally speaking, you shouldn't be referring to other documents in your TRO. Everything should be, you know, as attached to the TRO. So if you're, for example, attaching a client list, if it's like a case that has a non-solicitation and you're attaching the client list, as a general rule, you should have that client list. If you need to file it under seal, you know, you can do that to protect the confidentiality of the information contained therein. But the other side, if it's something that you email to them separately, and it's not actually part of the TRO, that could jeopardize the enforceability of the TRO, or at least as to that exhibit being part of the TRO.
Yeah, that was something that we wanted to mention. Your client list is the trade secret itself, but how do you have this seemingly conflicting provision of having to include the client list for specificity, but you also don't want to waive that client list by putting it in the public realm. And there's a procedure that Meghaan mentioned, is filing it under seal, where it's part of the document, but it's not in the public records. And that is a very specific procedural requirement that also has its own pitfalls and nuances, but that is something that you would want to look into if you are filing something under seal. Make sure you look at those statutes very clearly. All right. The TRO also must state the date that it expires. We've said this a few times. It only lasts for 14 days, but you can get one extension. It's pretty interesting that they limited it to this, but there's a very limited power of the court to only give you one more extension up to a 28-day total, and it can be extended by agreement of the parties. But if you don't have that agreement, you really are limited, and that's why, as Meghaan said, adding an expedited discovery schedule is important. You have to have your temporary injunction date in there. We've had cases where the other side may try to delay a little bit to get a gap between the TRO and the TI hearing. It's very important that you confer frequently and make sure the court is aware of these conferences, so that there is no gap between the TRO end date and the actual TI, because then you have a risk of 2 weeks to 2 months of non-protection of your trade secrets or potential solicitations of your customers. And then finally, fixing amount of the TRO bond. That's going to be a separate slide. That's coming up next. Last thing I'll say on extensions, here's some of the rules if you want to go look further about when the 14-day expires, what it requires to get another 14 days. And you actually have to extend it before the TRO expires. So you can't say, hey, I'm a day late, could you just help me? Can I get a new TRO? That is something that is possible. It is rarely available, but it is, and I'll say it's not best practice. You don't want to be telling your client, hey, this TRO lapsed, I have to refile this whole thing, and now the other side's probably going to show up for this one. Yasser, I don't know if you had any experience, but I think you would agree best practice is not to let it expire before you have to go redo another TRO.
No question about it. You have to keep that thing alive. Make sure that you take adequate steps to, if you believe that you're not going to get a temporary injunction before the end of the 14 days, the minute that you get that suspicion, you go ahead and automatically file a motion for an extension. You have to keep it alive. If you let it lapse, then the process that's the end of the process. You have to start all over.
And it's statutory, so you may have to request an emergency hearing if the court clerk says, look, the judge isn't available for another month. You may have to file an emergency hearing to get that hearing before it lapses. All right, let's talk about my favorite, all the different bonds.
Sure. So, and I know we don't have very much time, so I'll try to be brief in talking about this. I mean, the gist of it is that you have to have a bond to support the TRO. The judge is going to set that. Oftentimes, they'll ask for input as to what amount you think is appropriate. Even if you have in your agreement that the parties have waived the bond requirement, do not rely on that. Go ahead and get a bond, even if it's a small bond. Generally speaking, the idea, it has to have some kind of relation to the harm that the defendant is going to suffer if the TRO were improperly granted and they're improperly enjoined. I generally see it depends on kind of the level of the case, anywhere from and how many defendants you have. But, I've seen it as low as 500 and as high as, if you have multiple defendants, for example, 5,000 per defendant. So you have to post a bond in order for the TRO to actually be issued. And so once you get the bond in place, basically there are various different bond companies, insurance companies that you can call. Honestly, you can fill it all out online to get your bond, and you'll pay just a certain fee for that bond. And then you get the paperwork from the bond company and you file the bond certificate with the court. And it's actually a pretty relatively straightforward process, but you can't forget it because if you forget to get the bond, the TRO will not be actually valid.
All right, and we may go 5 minutes over, and that's we've been approved for that, but we do want to get to the most important part, and that is the practical considerations and the practice tips. So let's make sure we dive into that right away.
So, by the way, I'm going to apologize to everybody. I have to drop off exactly at 1 o'clock for a court hearing, but this is very important. This is a key decision. Should I get a TRO? Because remember, you can get a TRO, and getting the TRO has its advantages, as we discussed. You don't have to effectuate service of process. You could just have to provide notice. It gives you full protection from the beginning of the filing of the lawsuit all the way, hopefully, through the end, if you convert it into a temporary injunction and ultimately get a permanent injunction at trial. But at the same time, you don't have to get it. You could theoretically skip the TRO and just move for an injunction. And it leaves you unprotected for a period of time. So there's pros and cons in deciding whether to actually pursue a temporary restraining order or not. So what are some of the pros? Let's go back. So the pros, it has the ability of you actually setting the stage for, if you get a temporary restraining order, you have the ability of educating the judge, getting the judge to agree with you. If you get the temporary restraining order, it serves as leverage. It can which causes opposing counsel to perhaps agree to enter into an agreed temporary restraining order, as opposed to having to go all the way through the temporary injunction phase, which is a mini trial. It has the ability to set the stage for expedited discovery. Some of the cons of going with the temporary restraining order are that, conversely, if you don't get the temporary restraining order, just like if you get it, you have the ability to educate the judge and get him on your side. If you don't get it, then the judge may have a predisposition against your position. The other thing is the temporary restraining order initiates expedited everything. This practice, trade secret misappropriation practice, is a lot of fun because it's a lot of courtroom experience. You're constantly going to trial. If you like being in the spotlight and being in front of a judge and developing your advocacy skills, you're going to love this practice. But it's just go, 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 go. And one of the cons of actually pursuing that route is that you're going to have a total of possibly 28 days to prepare for a temporary injunction. And you're not going to be able to get an extension absent opposing counsel agreeing. So be careful what you wish for. If you pursue that route, you're going to have to be ready to oftentimes not sleep for a month and get ready to try the case in short order. Okay, next slide.
And Yasser, we know you have to head off, and Meghaan will definitely help with the rest of the practice tips. But what is your parting words? I think you mentioned the experience for young lawyers. What are your parting words for young lawyers interested in trade secrets and TROs?
Jump in. If you love developing your advocacy skills, this is a great practice. You'll get a lot of opportunities to become a good trial lawyer, be a perfectionist. There's no substitute for putting in the work. Make sure, like Meghaan said over and over again, it's all about perfection. It's all about attention to detail, like Miles also said. Make sure that there's a lot of statutes that are at issue, particularly in the context of getting an enforceable temporary restraining order and injunction. Make sure you track the language. Make sure that you don't rush through it. It takes precision, but when you get that win, it's well worth it. So I'm sorry I have to leave, everybody. It's been an honor speaking to you. I hope you found some of this helpful.
Thank you, Yasser. We'll continue, and we'll people can reach out your bios online if they have additional questions. They can email you. I know you're welcome and you're very approachable.
By all means, I encourage it.
All right. Next slide is how long before the TRO do I need to give opposing party and its counsel notice? This is a very strategic decision. You do have to give them notice, but it used to be where there wasn't, judges didn't necessarily require specific like 1 or 2 days, and there's not really case law on it, but it does have to be reasonable notice. And I think nowadays with Zoom, it is easier for them to appear. I remember having one case where there was an emergency situation, such as the embezzlement situation, where we thought they were going to destroy all the evidence right away. And so we did have to give them pretty quick notice. It might have been that morning that we had to give them notice, and we filed that afternoon, and we had the hearing that afternoon. And I understand that sometimes that, if you're defending these TROs, you do have to be on the call. If that's your part of your practice is defending TROs, is being available for your client. That goes to client services, picking up the phone when they call, being able to go to the courthouse right away. But nowadays, if a lot of things are over Zoom, that helps. So I'll let Meghaan talk a little bit about kind of the new era versus what it used to be like.
Yeah, I mean, I think, generally the first question that is asked, certainly in Harris County, with the ancillary clerk will ask you when you're asking to get a time for the TRO, because now, certainly with the pandemic, it's no longer you kind of just go to the courthouse and, wait to get heard. It's now, basically you're emailing or calling the ancillary clerk, who's the gatekeeper, and they're going to tell you what time you can get a hearing. And he's going to ask you, have you given the other side notice? And he's not going to schedule you unless you've given the other side notice. And by that means, sending them an email. It's not like you have to try to, track them down. You don't have to send them an email and call them and until you can get in touch with them. But you do need to do one or the other. If you have a good email address, sending them an email with a copy of the petition that you filed and letting them know that you're seeking a TRO. And then if you get a hearing time, following up and letting them know, here's the hearing time. Quite honestly, I think I think it used to be the strategy was to give them as little as notice as possible, so it would be ex parte. But in today's world, where everything is being done by Zoom and everything's actually getting scheduled, the judge, a lot of these judges are going to want to give an adequate notice and that they have an opportunity to appear if they can.
And Meghaan, I remember our case in September. We briefly mentioned it. I think we might have given them 1 or 2 days notice, and then they just didn't show. So are there a lot of instances you see where you provide the other side notice, they don't show, but the judge says, well, I'm not going to do this unless they come, despite the fact that they got notice?
No, I haven't really had that happen. I think the judge wants to just make sure that you've given notice and see what kind of response, did you receive a response or not, but generally we'll still hear your TRO. I've never had a judge decline to hear it because the other side didn't, because they wanted to give the other side an opportunity to appear.
Right.
And we've talked about the judge a lot, so and we've said the term ancillary judge. Let's talk a little bit about that. So it's not, some question maybe, well, what judge do I get? In Harris County, there's actually a specific ancillary docket where judges are on a rotating basis. And so the judge that you have for the actual case moving forward may not be your TRO judge. That's the ancillary judge. And they serve on it for about half a calendar month, but that is who you're going to be arguing to. And it may not be your judge moving forward. Again, back in the day, you'd look online, you'd call up a clerk, you'd try to find somebody that could tell you who the judge is or who it may be coming up. But you might be stuck. If you have to file this right away, you're stuck with whatever judge is sitting that day as an ancillary judge.
Yeah, that's right.
Go ahead. Anything else, Meghaan? Sorry.
No.
All right.
And Miles, so yeah, what you just said in the ancillary docket begs the question of whether you should wait for a TRO. The ancillary, when you're getting ready to seek a TRO, you may go to the website, which we've put conveniently on the slide, and you'll see that the ancillary judge perhaps is a judge you've been before and you didn't like his or her rulings. Well, then you, of course, have a choice. The pro of that is you can wait for a more quote unquote friendly judge. But of course, as I said, the website that we provide in the Harris County, of course, provides only posts who the current ancillary judges. It doesn't post who the next ancillary judge will be, and the ancillary judge after that, and so on and so forth. So of course, the cons to waiting is, well, I don't like this judge, but you're then basically gambling on whether you're going to like the ancillary judge after that, and you won't know until the ancillary judge is announced. Of course, if you also wait, the whole point of the TRO is to prevent irreparable harm. If you wait to get your TRO, you may be harmed irreparably. And to that point, opposing counsel may say, well, listen, you filed this lawsuit and didn't seek a TRO immediately. Isn't that showing your harm wasn't irreparable? So you may, if you wait to seek your TRO, you may have a fight over whether their harm was irreparable because you didn't act fast.
And often they'll look at the attachments. Like, let's say sometimes you find out about a need for TROs because one of your customers will accidentally email your client using the auto fill-in and forward you the chain where your former employee is using your information. And that's, the date of that, the date of your exhibits, the judge is going to look at and say, when did you find out that this was happening? Your client got emailed notice that this person was soliciting clients, 2 months ago, and you're just coming to me now. So the exhibits will tell the story as well, showing how long you waited or not. Pro tip: use is not necessary to secure a TRO. There's something called the inevitable disclosure doctrine. It's been litigated a lot, but it's pretty much saying this person is in a role so similar to what they were in a role for us. It's inevitable that they're going to disclose or use our trade secrets. Threatened misappropriation can be enjoined. And this does come in a lot of issues because if you're a defendant, you want to argue this isn't a trade secret. This was in his head. He's allowed to have his general knowledge and skills when he goes to another employer. He's allowed to know, hey, I'm supposed to call up, certain customers in this industry, versus the plaintiff who's going to say, no, these are my specific compilation of customers. He took this list with him. And again, the defense will say, well, he was just basing off of his memory, not what's on this list. And that'll go back and forth throughout the case. But the point is, if it's inevitable or if it's likely inevitable that he is going to use the stuff that he took from you, a TRO may be granted. And Meghaan, do you have any input on that? Because I know you may have dealt with the use issue a lot.
Yeah, I mean, look, judges are more willing to grant, in my experience, a TRO when you're seeking to stop the other side from using your confidential information and your trade secrets, provided you've adequately defined what they are with enough specificity in your TRO, even when you might not have that, mounds of evidence, right? But you have kind of like what Miles said, at least a circumstantial, this is, you have some kind of forensics or something showing that they took something, or they may have taken something because they were plugging in devices, for example, and now they're going to work for a competitor in the same exact role. Oftentimes that's enough to at least have a judge, shut them down from using your confidential information or your trade secrets. Now, in the absence of a non-compete agreement, they're going to be not very inclined to say that they can't go and work for that competitor. You'd likely have to have some type of contractual agreement that's prohibiting them from doing that, because judges are really reticent, and even then to put somebody out of work. That's kind of what my experience has been.
Thank you. And we talked a lot today about TROs and forensics. We said that forensics is something that's really important, but could do its own presentation. The next presentation we hope to give everybody, this is pretty much the end of today for TROs, but the next presentation we'd love to give, for HYLA or in the future is on temporary injunctions specifically, and then possibly the use of forensic evidence, computer records, and spoliation. So that we know we've taken a little bit extra of your time today, everybody. If you have any questions, I don't see any in the chat right now. But if you have any questions, we still have we can stick around for another minute or two and answer any follow-ups, but we do hope this was helpful to explain the basics of TROs and trade secrets. And
of course,
go ahead,
to
Ryan.
the extent that you have, any questions arise in the future, whether that's 5 minutes from now or 5 days from now, next slide, Miles, feel free to email us, and we will be happy to answer your questions.
All right. Thank you, everybody. Meghaan, thank you for your time today. And Ryan, thank you.
Thank you.
Thank you, everyone.
Bye-bye.